Preparation's the key. Preparation, preparation, preparation. The first thing you need to do is understand the problem from your client's perspective, which means just not the legal issues but the non-legal issues and how it's impacting, what interests your client has invested in the dispute and how it's impacting on them.
I think the parties should come to the negotiation with an open mind. A lot of the times you'll find out a lot of information that you would not be aware of before coming to the negotiation. And if you can keep an open mind, it helps you to generate some more creative and out-of-the-box options.
The main component of any successful negotiation is planning. You have to read the question thoroughly, you have to plan it properly. From that, you can then use your negotiation techniques. So things like working out what your client's interests are, working out what the other side's interests are, and then you can actually use that to come up with some options before you walk into the negotiation. But planning is the key. If you don't have a plan involved and you don't have an idea of what for example, what your BATNA is, which is your best alternative negotiated agreement, if you don't have an idea of things like that, you're not going to do very well. So basically you need to have everything set out, especially for the questions that you do for these style of negotiations, you need to really read them thoroughly and try and reach from the subtext what the other side wants, what you want, come up with some options, and also and then go in there with that.
Good evening, Harriet Skinner.
Hi Harriet, I'm Pedros.
Hi.
Hi.
Ren, nice to meet you.
Hi, nice to meet you.
Pedros.
Ren.
Nice to meet you.
Guys, we come here today in good faith and confidence with full authority of our client to settle the matter today.
One of the things that we did when I negotiated with Ren when we were at uni, and one of the things that we did was to come up with an agenda, setting out ground rules at the start. If you read the book Getting to Yes by I think Fisher and Uri, that's a really good book to read, and also Getting Past No is another book that they've done. If you ever get a chance to read those two books, we did before we started doing both junior and senior negotiation, and it's a really great book, not only for these negotiations, but for your working life, even for your home life, things like that. Basically, it teaches you different techniques, ways to look at things, ways to consider interests, and that's the key. When you stop talking about positions, so for example a monetary figure, and come up with various interests, that's when you're going to do really well in these negotiations, because they're set up for you to identify interests and negotiate in what's called the interest-based negotiation. Basically you're looking to make the pie as big as possible rather than trying to divide what's left. So that's probably the advanced technique I'd say you'd want to have on board.
You should always go into a negotiation fully prepared, and part of that preparation is having what's known as your best alternative to a negotiated agreement. This is a worst case scenario in case you don't reach agreement, how you will deal with your problems if you had to walk out of there without an agreement. And as long as you know your position in that situation, you can measure all the other options generated against it to see if they're better or worse.
The biggest thing to avoid doing is to get into an argument with the other side. A lot of the problems that happen in negotiations, particularly for these kind of competitions, is you get what's called bogged down, and so basically you'll end up arguing the merits of a certain situation. That's something that needs to be avoided at all costs, because what ends up doing, you've got a limited amount of time. You've only got about 50 minutes or so. Plus, and included in that is any breaks you have to stop, reassess your strategy and move on. So timing is critical. If you can avoid getting bogged down and try and deal with as many of the substantive issues as possible, that's the best way you're gonna get through the negotiation.
One thing that I find a lot of people do is they focus on the positions rather than the interests of what their clients are actually trying to achieve. So I would say that if you could not entrench yourself with one option, one position that you came here to achieve, then you'd find it a lot easier reaching an agreement.
Perfect. Well, the same goes for us. What we'd like to do is we've got an agenda here that we'd like to go through. Basically, the way we see it is there's more than enough interests and options here that we can come up with a mutually beneficial agreement.
Just to run through, I suppose, the basic structure of what we'd like to do. First, we'd like to explore each party's interests, to see what it is that compels each party and what each party hopes to achieve out of the negotiation. And once we have that out of the way, we can start generating some options without criticism at that stage. And once we have all of our options on the table, we can go to discussing those options and picking out the most appropriate ones to help both parties reach a mutually beneficial agreement.
Perfect,
Well,
that
that
sounds
sounds
great.
good. Please take us through your agenda.
Well, it takes two to have a confrontation, so you don't play their game. You don't react belligerently. You respond by acknowledging their right to feel how they're feeling, but always bring them back to the points of common interest between the parties, and that you're there together to try to resolve the dispute. It's certainly far and away the most effective way to resolve any dispute, primarily because, of course, the parties have control over the dispute and the outcome, but also because it means that whatever is the result of the dispute is achieved by the parties working together and focusing on what their interests are, whereas a judicial determination is very limited. The power of a judge is effectively only to order who pays what amount of money, and there's no ability to focus on the common interests of the parties or an outcome that would satisfy an ongoing relationship.